Hello, and thank you for joining us on today's Ask Andrew show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the founder of Feldstein Family Law Group with offices located in Markham, Vaughan, Oakville, and Mississauga. Both myself and the entire firm practice exclusively in the area of family law in the province of Ontario. Today, I'm joined by an activist and part-time professor, Leighann Burns. Leighann began her activist journey by accompanying survivors of violence to legal appointments and to family and criminal court. After going to law school, she dedicated her career to practicing family law with survivors of violence. She teaches part-time at the University of Ottawa with the Faculty of Law. And welcome to the show, Leighann.
Thanks, nice to be here.
Okay, today I wanted to examine how spousal abuse has been addressed historically under Ontario's family law regime, and by considering broader cultural, legal, and gendered assumptions that have shaped those responses.
Okay, well, just to put this in context, I began working as an outreach worker for a women's shelter 35 years ago. So I spent a lot of time going to court and to lawyers' appointments with women back then. And that was prior to things like even the child support guidelines. So it was not unusual to go to court with women and hear a perpetrator list his monthly budget that included everything but supporting the child. So there have been things like the child support guidelines that have come along and made a huge difference in terms of changing the game for survivors of violence. So Ontario was actually ahead of the federal government in terms of dealing with violence against women. They made consideration of abuse mandatory in 2006 under the Children's Law Reform Act, following an inquest into the post-separation murder of Gillian Hadley in 2002. As with many changes that have come along, it's following a horrific incident of murder of a woman or a child that we actually make the changes that are needed. So it took a while for that legislative change to have the desired effect, with more and more reported cases appearing over time, but the Divorce Act was still silent about abuse. So I did some in-depth examination of what was happening when women pleaded the abuse in family court cases. And we reviewed 108 Ontario trial decisions. And when judges, what we found was that when judges decided cases under the Children's Law Reform Act alone, which required consideration of the violence, it was found as a fact and considered in more than half the cases, 52% of the decisions, compared to only being found as a fact and considered when cases were decided under both the Children's Law Reform Act and the Divorce Act. So that dragged it down to 35%. So it was clear that legislation would change, has an important role to play in terms of how cases are decided. And we also did a file review of 338 family law files in 2016 and found that abuse was pleaded in just over 17% of them, which was below the expected prevalence rate of 25%. And we also found that violence did not show up in the one place it was required to be disclosed in almost half the violence files we reviewed where violence was a factor and was declared somewhere else in the file. So in 2010, Ontario has required mandatory disclosure of violence in an affidavit, a 35.1 affidavit. In 47% of these mandatory affidavits, the file failed to disclose the abuse where women had identified it in the pleadings. So, and in 91% of those cases, women were represented by counsel. So that was a really troubling.
So I'm a little confused then. So what you're saying is the lawyer drafts the application for divorce. It has lots of mentioning and discussion about the violence that existed during the relationship. But when they went and did the 35.1, which for our viewers is an affidavit that you have to complete at the time you commence your application, they omitted to include the very same violence that is mentioned in the application.
Precisely. And nobody seemed to notice, which was another thing that was really striking about it, that we made these mandatory affidavits, but nobody seemed to be paying much attention to what was in them. The other thing we found was that custody claims occurred more often in the violence files than in the non-violence files, 73% versus 43%. And women in the violence files sought sole custody, as it was called back then, more often and received it less often than in the nonviolence files. So
I
that's
guess
how we were doing.
I guess I'm not surprised to see that if there's allegations of violence, they go hand in hand with an application now what we would call sole decision making rather than custody, because the theory is you can't do joint custody or joint decision making if the parties can't get along. And if there's violence, you can't get along, so somebody has to make a decision. I get the logic of that, but how would you explain the aspect of it that I think it was 73% of the cases where violence was pled, they didn't do as well in seeking joint decision make as in seeking sole decision making.
Well, I think there's it's some of the other research. I won't bore you with all the various kinds of research I've done, but one of the things I looked at was the level of education lawyers get, what they get in law school and in bar exams and so on. And there's a knowledge deficit amongst in the profession, or there was up until the Divorce Act changes came into play. And there still is to a certain extent. And even with Kira's law, the change that is making education for judges mandatory, it's not for sitting judges, it's for new judges. So there's still an educational deficit that's going to be with us for a while.
Okay. Well, it's interesting as you say that, because I mean I spend more of my time in a unified family court than non-unified family courts. I think more judges are well aware of that issue than not. It's, I think, a greater risk when you're going to a non-unified family court and you have a civil judge that says, well, they threw me in family law today and I really don't know much about it. That's where I see probably the gravest risk of someone not being aware of the intimate partner violence. And for our viewers, they should understand that in Ontario and Canada as a whole, there are courts that are a unified family court. When you go to court, you most of the time, but not all the time, will get a judge that practiced a lot of family law before their appointment and usually will sit exclusively in family court. There are other courts that do not have a unified family court, and you can get a judge that practiced personal injury for 25 years or corporate commercial, may hardly ever sit in family court, but is sitting in family court for that particular date. And that may seem counter to common sense, but that's where we are. And as I once was at an event that the former Chief Justice of the Superior Court of Justice, which is where a lot of cases are, was sitting, and she said, you know, the Superior Court of Justice is a court of generalist judges. And that seems really unfortunate. You'd like to think when you're going to have your problem resolved, especially one as important as the breakdown of your family, somebody is well versed in the law and the nuances that go along with it. Maybe nuances isn't giving it the breadth that it needs, but intimate partner violence is an important aspect of family law. And you'd like to have judges who are aware of it to properly understand it. And the unfortunate aspect is we can do as much as we want to educate and teach, but if you don't have people who are doing it day in, day out, or at least a lot of the time, that's going to be part of the shortcomings as well. And I don't know if you'd agree with that kind of viewpoint.
I would. I think part of the challenge is that much of what happens in abusive relationships is counterintuitive. So, you know, it's not plain on its face what's going on. So you have to have a certain level of awareness to sort of figure out the actual dynamics that are at play. I went to visit a unified court in, I think it was in Buffalo, where it was combined criminal and family. And there were designated judges that sat in that court all the time. And I thought that just constant exposure would result in a greater knowledge level, but that didn't seem to be the case. So I think there has to be a combination of really pointed education and experience that go hand in hand. And I will say, notwithstanding all the doom and gloom to date, things are looking up.
Well,
So
that's a good thing. And one of the problems too, I see it, and I teach this to my young lawyers, and I see it from other lawyers, is when you put in your court materials, the relationship was riddled with abuse, as an example. People aren't going to hear that because it's very easy to say, my relationship had a history of abuse. You need to be able to tell the story of what took place.
yep,
Because when you tell the story, that's where a judge gets to say, oh, that makes sense. Because I know you say it's counterintuitive, because until you read about domestic violence and intimate partner violence, it runs counterintuitive that somebody is abused, stays in the relationship. But that's exactly what they do.
exactly.
But then, you know, I always say to people, tell the story. And when you tell the story, don't throw in a bunch of unnecessary adjectives, because if you say, we went to my in-law's birthday party for my father-in-law. My spouse got really angry at me because I said something or I wore something inappropriate. And when he came home, he screamed at me after the 50th birthday party, put his hands around my neck, choked me, and threw me against a wall. You don't have to say that was a violent act. It's pretty obvious. And and when you're saying that it happened after a certain event that makes it easy to tie in,
Yep.
that's what makes it easier for a judge to understand. And as lawyers, we have to look at the facts our clients are giving us. Because one of the other things that I hate is when somebody says to me, well, my former spouse harassed me all the time and I'm scared of him or I'm scared of her. And then you say to them, well, if you say that you were harassed and you're scared of them, why did you keep on after you left the home? You have a new residence, the kids are with you. Why did you go over there to scream at him to get that extra chair that you wanted? Because if, when you hear that, and I get the argument of counterintuitive, if you're a victim of violence, the last thing you're doing is going and fighting about a chair. You're not going to start up with that perpetrator of violence.
Exactly.
You're
I
going
wouldn't know
to,
anybody that would have done that, going to get a chair.
I'm giving that as an example because I've seen cases where somebody says you're harassing me and then phones them 10 times.
Right.
Well, why are you phoning the harasser 10 times? You
Right.
don't do that. The counterintuitive nature is staying in the relationship. But
Yep.
once you're out of the relationship, usually the victim, the last thing they want to do is poke the bear. And one of the things they're really scared of is even walking into my office and starting a case. They are petrified of it.
Exactly. And that thing we know for sure is that violence is underreported, not overreported. So that is for sure. The other thing that um, I had a woman say this to me once, and it makes perfect sense in terms of the counterintuitive nature of staying in the relationship. She said, it's easier to deal with him when I can see him in the living room than worrying he's around every corner, So that makes sense. I get that.
I, and I get that too. And I also get that some people will stay in the relationship because they say, well, I'm scared to report it to the police because he makes a good living or she makes a good living and he is paying all the bills. And if I go to the police, he may lose his ability to travel, which he needs to do to make a living. And that's a real common problem that we create in terms of the fear, because that arrest may cost that other person to lose their income. And now they're going to say, well, I don't have any money to pay child support. I don't have any money to pay spousal support.
Right. Yeah, I mean, it's tricky, right? I mean, we could do a whole other show just on policing violence against women and the pros and cons of mandatory charging and the realities of mandatory charging. Because I think we have, despite the fact that it's been a leading core element of our efforts to end violence against women, we haven't done very much to actually analyze its impact and to understand what actually happens when women report violence. So,
Well,
uh,
and some of it has to do with how the police treat it, and like you say, the mandatory charges versus does both the family need counseling on how to better deal with it? Because there, it's a hard thing of trying to say, well, what's a reasonable line? There, no line of violence is acceptable, no assault is acceptable, but what can you do to try and at least fix their ability to communicate, whether they're staying together or not staying together, because they're still going to be stuck as co-parents going forward. And how do we give people the skills to do a better job of that? Maybe better than spending the money on having a crown attorney spend the hours that they spend legal aid funding the criminal defense lawyers to fund it. I don't know the answer to that. I'm not an academic like you are, but sometimes you see people, and when they get insight into their own actions, they have some remorse for it.
well, I think the key is deterrence. And there are those who debate the impact of charges, but I know from my own experience that with some perpetrators, just the charge itself will snap them out of it and he'll stop the behavior. Some perpetrators, charging will have no impact whatsoever, and we have to deal with them separately because they're going to do what they're going to do regardless. But for some, having that wake up call and a clear message that if you do this, you're going to be held accountable, will, change the behavior. And then they, get put into, counseling programs that, there are also debates about how effective they are. But, we have a whole regime around this whole thing that when all the parts work together, ought to have an impact in terms of controlling his behavior. Because we have to also remember that his objective is control, right? He's trying to maintain control, and if she leaves, he's going to up the ante to try to get control back. So
Well,
all of our messages have to be really clear that you're not, if you do this, it's going to be more trouble than it's worth.
well, it's, you see a lot of cases where the ultimate question is power and control. And if you take a traditional relationship where the mother was, and this even without violence, the mother's the stay-at-home mother, the father went to work, he had control of the money, the mother had control of the kids. Then when the separation happens and the mother asks for support, now she wants some control over the money. And the dad may be interested in the kids, but also now is a lot more interested in a lot of things because that's his way of maintaining control to a certain extent.
Right.
So there's always that element of power and control, and we always have to balance it at trying to appreciate what people's needs are to get them to a resolution. Because the more conflict, from your vantage point as an activist, probably I would assume more conflict increases the probability of more violence, and more conflict certainly increases the cost.
Yeah, that's another consideration. Family court is almost becoming impossible for, especially for survivors of violence, because the agenda of the perpetrator is often not about resolving the legal question. It's about continuing the abuse. And so that can drive up legal costs pretty quickly. So lawyers have to be really alive to that and try to, you know, keep it under control in terms of the costs involved.
Well, we have certain problems that we will have clients who will come to us and they'll say, I don't care. I want to litigate. I know I'm right. One of some of the things I will say to clients is, if you can pay me 30,000 and I'm going to tell you maybe, or you can pay the other side 30,000 for certainty. I would rather pay 30,000 for certainty than pay me 30,000 for maybe. That seems like a no-brainer.
It's a good argument.
And then when they come to me with really foolish positions, I usually say to them, do you have a fireplace at home? They'll be like, yeah. I say, well, why don't you go to the bank, take that 20,000 for this motion you want, get cash, and go throw it in the fireplace. You're probably going to have more fun.
I wish you were the lawyer on the other side of all of my family law files when I was practicing.
But that's knowing enough to know that I don't want to go to court and represent a client on being foolish. I have no problem going to court and arguing cases that make sense. The judge may not agree with me, the judge may disagree with me, but I at least have to have some logic, because we as lawyers, we also have reputations. And what we don't want the judge to say is, God, that was a really stupid case that Feldstein argued today. That impacts our reputation too. But at the end of the day, I also don't want to take people's money for stupidity. We
Completely
charge enough.
agree. I completely agree, but there's no shortage of lawyers who will do it.
Well, I like to think most don't, but maybe I'm too kind in that regard. Uh, so as I go through this, we both know that there were significant amendments to the Divorce Act and the Children's Law Reform Act in 2021
Yeah.
that were very significant. How do you think that's impacting any changes that have happened since 2021?
Well, that's a really good question. And I have started another systemic review of case law, and I've got a ways to go before I complete it. But my impression so far is that it's having exactly the desired effect, that we're seeing recognition of the abuse, and it's factored into decisions around parenting and decision making and time spent and so on. So I think we're going in the right direction. I will complete that review and make sure of it, but things seem to be on the right track. And of course, there's the Barron Direct decision at the Supreme Court, where the court articulated really important information about violence that is giving good direction. You see that case cited over and over again. So we seem to be going the right direction.
See, and I'll say that there's a problem with the legislation too that I see is I have now seen a significant increase in allegations of family violence, which is also costing a lot of families a lot more money in terms of legal fees to get to resolution, because now a lot more cases are alleging them. So if that's the case, and maybe it's partly lawyer driven, I don't know, but if that's the case now, is there an unintended consequence that people's litigation costs are significantly going up? And then the question is, how do we temper that? Because our lawyers are, some of them, pulling out a lot more of what they want to call family violence. And is it really there? Or are they being suggestive of their clients to get their clients to say it?
Well, we know for sure it was underreported prior to the legislative changes, so we should expect an increase. Because it's mandatory to disclose it, and we should expect it to get up to the prevalence rates at which it exists. If people are overstating it, I would be surprised if they get very far with those arguments. You need to be able to put forward evidence that is compelling to a judge as well. And so if you're making allegations and you just bald allegations with no evidence to
No.
support it, I think you're
And
going to have trouble.
and that's what we see in so many cases, are at least that I'm seeing, is people make the allegation and they don't have a story. They don't have to, I understand people may not take a picture. I
Right.
understand people are embarrassed. So that may mean when you're assaulted by your spouse, you don't want to tell people about it. You don't tell your parents. You may not tell your best friend. Because
Right.
when clients who have come into my office who are victims, especially of some significant violence, you can see they are scared. They are
Yeah.
really scared and they don't want to do it.
Yeah.
But you see a lot of these bald face allegations with nothing backing it up. And that's where I see, at least as a practitioner, an upswing in legal fees on cases, because now all of a sudden you're probing with, okay, when did the abuse happen? It happened throughout the relationship. What was the nature of the abuse? He was violent.
Yeah.
And
That, that's the claim. It's not going to go very far without
I know,
any
but
detail.
but those are things that are costing money. And then you go and you're saying, well, the equalization payment is X or the proceeds of sale is Y. And the other side says, but my family violence claim.
Mm.
And that's where some of it I see the leak. And I'm saying I may be wrong. And it's anecdotal because I've seen it in my cases, but that's something that I'm curious to know as you do your studies, whether you see that and whether you're able to identify. Like I almost wonder, somebody like you who is studying so many of these cases, and if you're reading the pleadings or you're reading the 35-1 affidavit, and you say, man, that's a horrible story. I'm almost curious to know if you could do a tick mark by looking at the application and then look at the ones that get to trial, whether you had the correct insight to pick the ones the judges that ultimately agree with you on.
It'd be interesting to see. I don't know. That'd be a good way to look at it. I mean, I've been at this a long time, and so I can usually tell pretty quickly whether the story rings true or not.
And that's my point.
Yeah. So,
And that's the problem I hate, because I hate when I see someone with bold-face allegations, no comments, and when it's my client, I challenge them on it and say, tell me more.
yeah.
Tell me the details. Give me the details. And it could be sometimes it's just good lawyers versus bad lawyers that don't pull the details out.
Yeah. I mean, that would be a really disappointing development if we had lawyers going from not addressing violence and under addressing it and now fabricating it almost. That would be a really unfortunate trajectory. I hope that's not true, but I'll tell you when I finish my review, I'll let you know what I find.
I would be very curious to hear that. And it may also be, I deal with a certain segment of the population. We don't do any legal aid files. We do people who have earning capacity. And that means I'm playing in a different playing field than some other people who are on legal aid certificates and are financially challenged.
Mm-hmm.
And that may play a role in the statistics. Anecdotally, I've always had people say to me, and I don't do children's aid, I did it for a little while, but people would say, why is it always that the children's aid cases are people who economically are not in a very good place?
Mm-hmm.
And people who are in a good place don't seem to have problems with children's aid. Are you telling me that wealthy people don't abuse their children? Well, that wouldn't be true. And
Yep.
and my answer is usually walls are thin. People who don't have money are living in buildings, and people hear what goes on versus people who live in houses and don't hear. And people who have money and have education also have a better understanding of how to deal with the state when the state comes knocking on your door.
Right. And the state is a lot less intrusive when you've got money than it is when you don't. And the other thing is, poor people are much more visible generally because they're accessing various sort of resources. So they're
So,
visible in the community in ways that people that have resources aren't.
so if Children's Aid knocks on my door, I'm going to be smart enough to talk to them, hear what they have to say, and if they tell me, you didn't handle that the best way. Maybe you should go take a course on it. Whether I theoretically agree or not, I'm going to say okay, because I know that I go take the course, I complete the course, they're probably not going to be in my world anymore.
Right.
But
Yeah.
some people believe, who are you going to be to tell me to do this? Well, now you're on their radar,
Yeah.
front and center. So, I look at that and say, well, maybe I'm not getting a proper cross section of the public from what I see in my practice in a similar way as Children's Aid. A lot of the things are going on, but people who have a little more sophistication and a little more money know how to sell things in a better way about themselves.
May very well be true. That's for sure. But one of the equalizers, I think, is often the contact with child welfare in these cases comes via police response. So the police respond to the scene and involve child welfare. So, it's an access point that anybody could encounter. And then, as you say, how you handle it probably changes the trajectory of where it goes from there.
Yeah, because what they want to do, and most people don't appreciate, a children's aid worker wants to close their file.
Sure. Yeah.
People think that they want to take the kid away from them, and it's the last thing they want to do.
Yeah.
So you want to give them the reason to close the file. And sometimes it's okay to say, man, I had not from a criminal perspective, but it's okay to say, you know what, I had a bad day. I made a bad judgment call. I got to do better.
Yeah. Well,
Judges and CAS are going to respect that more.
yeah, I think that's true. I also think people by and large don't necessarily realize the impact on children of growing up in a home where abuse is taking place, whether they're directly abusing the children or not. Just living in that home increases the risk for the children. And I don't think parents necessarily turn their minds to that. Um, there's been a lot of effort in Ontario and probably in other provinces as well to improve the child welfare response to these cases. And we have made some, in Ottawa, we worked really hard to improve the child welfare response. And we ended up having children, the files were kept open longer, but there were fewer children in care. So, their intervention changed. They had to do more work, but they kept the kids out of care, which is the goal, right?
Well, it's the goal, and I think it's a wonderful success, because sometimes you see, just sitting at the courthouse on a Children's Aid Day, not that I do that as often now since COVID, but when you're there and you hear the lawyers talking in the hallway, or you hear some of the story, and you think to yourself, what chance do these children even have right out of the gate?
Yeah.
And,
Yeah,
and
that's the
that's the
thing.
saddest part.
Yeah. That's the thing about all of this, is that all of this impacts kids. So we have to be thinking in terms of how do we achieve the best outcome for these kids, and exposing them to violence, exposing them to, whether they're being directly abused or whether it's happening in their home to their mother. All of that is harmful to
And,
kids. So we got to figure out a way to prevent those harms.
and even when there isn't violence, for the viewers, conflict is bad for kids.
Yeah.
Even after separation, the conflict is bad for kids. And unfortunately, there's going to be consequences arising from the conflict, because that's what these children know. And part of the message we're teaching our children is this is what a dysfunctional relationship looks like. And in their eyes, that's their normal. And that's not what we want to give our kids to see. This is the normal. So then they get to go do it all over again, mess up their kids the same way they got messed up.
Exactly. That's the thing we have to bear in mind, is that for children, this is their whole world. They don't have another life to compare it to. This is all the information they have, right? So we're shaping how they see things.
So I see that we're out of time right now, but I wanted to thank you. I know we got a little off track, but I think the information you gave was really helpful, and I found it interesting. Uh, so thank you for joining us on the show. And if to our viewers, if you're looking for assistance as part of your separation or divorce matter, please feel free to contact us on our website, separation.ca. The next Ask Andrew show will be on Tuesday, September 30th at 12 noon. And if you have any requests or ideas for future shows, please email them to us at info@feldsteinfamilylaw.com. And thank you for watching.